everyone, and welcome back to the channel. This video will be as long as I can manage to keep Liberty Toddler at bay. Hi! But it is some big news and good news, and I don't feel like there are a lot of opportunities to give you guys good news, so I am going to take it, feral baby or not. The big news is that a judge has struck down the ATF's frame and receiver rule, saying the ATF overstepped its bounds. Yeah, it's exciting, into the realm of making new law. I'll get into the details of the decision, what it means, and why the battle isn't over quite yet, but first a quick word about today's partner. I want to thank My Patriot Supply for supporting the channel. With inflation skyrocketing, a seemingly never-ending rotation of shortages, and society seeming to get bleaker by the day, it has never been a better time to make sure that you are prepared. Right now, My Patriot Supply is offering my viewers $80 off the 4-week emergency food kit, which means it comes out to less than $3 a meal. Whether you're concerned about shit hitting the fan or even just the bad weather of hurricane season, go to preparewithliberty.com today. A U.S. district judge in Texas ruled against the ATF and their frame and receiver rule, which arbitrarily classified frames and receivers as full firearms. Besides being ridiculous on the surface, it was also essentially a big old trap for gun owners, because they also differentiated between kits that came with a jig versus lowers by themselves, and some things qualified while others didn't, and all in all, it was very clearly something made up by people who don't know what the hell they're talking about. And down she goes. The lawsuit was brought against the ATF by the Firearms Policy Coalition and the Second Amendment Foundation, and also included JSD Supply, Defense Distributed, and Polymer 80. The decision by Judge Reed O'Connor reads, "This case presents the question of whether the federal government may lawfully regulate partially manufactured firearm components, related firearm products, and other tools and materials in keeping with the Gun Control Act of 1968. Because the court concludes the government cannot regulate those items without violating federal law, the court holds that the government's recently enacted final rule, definition of frame or receiver, and identification of firearms is unlawful agency action taken in excess of the ATF's statutory jurisdiction. On this basis, the court vacates the final rule." The decision is 38 pages long, so I won't read you the whole thing, but here are the biggest arguments. First, some of the individual plaintiffs were folks who wanted to buy their own firearms but claimed they couldn't anymore without extra fees, time, damages, and inconvenience, because now, instead of just finishing their builds, they would have to reroute all the parts through an FFL and incur transfer fees. The ATF looked at this and actually argued that the case should be thrown out because the people were just complaining about a $30 transfer fee that has nothing to do with the rule, as if the whole point was $30 and not a huge infringement on the Second Amendment that, yes, Fed Boys, is completely your fault. O'Connor pointed out that the ATF's argument completely glossed over and dismissed the fact that not paying the fee to go through an FFL would result in criminal prosecution by the ATF, which is kind of a big deal. The rest basically goes into the reasons why the ATF can't just go around making up semantics. Parts that may become receivers are not receivers. Congress carefully defined its terms in the Gun Control Act. The primary definition of firearm in the GCA contains 3 parts. Any weapon, including a starter gun, which 1 will, or 2 is designed to, or 3 may readily be converted to, expel a projectile by the action of an explosive. Under this primary definition, a firearm is first and foremost a weapon. Then, because weapons parts are also not weapons, Congress created a secondary definition covering specific weapons parts, the frame or receiver of any such weapon. Notably, Congress did not cover all weapons parts, only frames and receivers, and only the frames and receivers of any such weapon that Congress described in its primary definition. Because Congress did not define frame or receiver, the words receive their ordinary meaning. Contrary to defendants' assertion, meaning the ATF, in an interpretive dispute over a statutory term's meaning, the court does not simply leave the precise definition of that term to the discretion and expertise of ATF. nor is the court bound by the agency's definition of an unambiguous statutory term, even if the ATF has long provided regulations defining frame or receiver. Plaintiffs do not take issue with ATF's 1978 definition of frame or receiver. This is because, as defendants themselves acknowledge, ATF's prior regulatory definitions have been consistent with common and technical dictionary definitions. Statutory construction entails following the plain and unambiguous meaning of the statutory language and interpreting undefined terms according to their ordinary and natural meaning in the overall policies and objectives of the statute. But the final rule's amended definition of frame or receiver does not accord with the ordinary meaning of those terms and therefore is in conflict with the plain statutory language. Departing from the common understanding of frame or receiver, defendants now assert ATF's authority to regulate partially complete, disassembled, or non-functional frames or receivers that are designed to or may readily be completed, assembled, restored, or otherwise be converted to function as a frame or receiver. And that which may become or may be converted to a functional receiver is not itself a receiver. As the court previously explained, the issue in this case is whether ATF may properly regulate a component as a frame or receiver, even after ATF determines that the component in question is not a frame or receiver. It may not. Logic dictates that a part cannot be both not yet a receiver and a receiver at the same time. And he's exactly right. This should not be a case of Schrodinger's frame or receiver. A part that has yet to be completed or converted to function as a frame or receiver is not a frame or receiver. ATF's declaration that a component is a frame or receiver does not make it so if, at the time of evaluation, the component does not yet accord with the ordinary public meaning of those terms. He applied the same logic to the ATF's claim that 80% kits are firearms, that the ATF doesn't have the authority to regulate parts, and that something can't be a part and a full gun at the same time. Moreover, the ATF's argument that they can regulate parts under the GCA would then extend into total wackadoo world of them being able to regulate all parts, which is nowhere in their job description. Next, the judge addressed the ATF's argument that historically they've made determinations and sent out letters on parts before. They said that the fact that they did it was proof that they're allowed to do it, which is circular logic, and to which O'Connor wrote, "If these administrative records show, as defendants contend, that ATF has previously regulated components that are not yet frames or receivers but could readily be converted into such items, then the historical practice does nothing more than confirm that the agency has, perhaps in multiple specific instances over several decades, exceeded the lawful bounds of its statutory jurisdiction."
Boom! Headshot!
The ATF also argued that the rule just seeks to better define what Congress was already thinking when they wrote the Gun Control Act of 1968, to which the judge basically said, "Buddy, if it was supposed to be in there, it would have been written in there." Congress could have described a firearm as any combination of parts that would produce a weapon that could fire a projectile. It used that language elsewhere in the definition. Congress could have described a firearm as any part designed to be part of a weapon. It used that language too. Congress could have described a firearm as a set of parts that may be readily assembled into a weapon as it did for a destructive device. Congress could have written all those things, and the very definition of firearm demonstrates that Congress knew the words that would accomplish those ends. But Congress did not regulate firearm parts as such, let alone aggregations of parts that are designed to or may be readily completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive. Accordingly, the final rule's attempt to regulate weapon parts kits lacks statutory support. There is a legal distinction between a weapons parts kit, which may be an aggregation of partially manufactured parts not subject to the agency's regulatory authority, and a weapon, which may be readily completed or assembled to expel a projectile. Defendants contend that drawing such a distinction will produce the absurd result whereby a person lawfully prohibited from possessing a firearm can obtain the necessary components and, given advances in technology, self-manufacture a firearm with relative ease and efficiency. Even if it is true that such an interpretation creates loopholes that, as a policy matter, should be avoided, it is not the role of the judiciary to correct them. That is up to Congress, and until Congress enacts a different statute, the court is bound to enforce the law as written. So hopefully Congress never does that. Now, what the decision doesn't do is address the constitutionality. O'Connor wrote that because it was clear the ATF overstepped, the courts don't even need to address the constitutional questions. It also does not necessarily mean the final death knell for the rule, as the DOJ is likely to appeal to the Fifth Circuit. But the Fifth Circuit has already been giving the ATF's bump stock ban and pistol brace rule a side eye, so I, at least, am cautiously optimistic. While these states and ATF are trying their damn hardest, the L's have been rolling in the courts for the left. Let's hope that the trend continues, and with that little ball of Spitfire energy here, who remarkably stayed mostly quiet, that is it for this video. Please do all of the algorithm things, like, share, and subscribe if you are new here. Ring the notification bell because Liberty Toddler demands it. And otherwise you won't know when I post a new video. And as always, thanks for tuning in and happy shooting. Yeah, you did such a good job.